an hour or so of discussion on a topic which we think is of great importance to our work in court, but which in no way refers to coronaviruses or pandemics. I'm delighted to be joined today by Chris Laughton. Chris is a corporate restructuring partner at Mercer Hole. He's a member of the Academy of Experts, and he represents the Institute of Chartered Accountants in England and Wales on the Joint Insolvency Committee, which sets the formal regulatory standards. He regularly acts as an expert witness in insolvency litigation. And in fact, I can testify to his abilities as an expert since I've been instructed in cases both where he's been called by us as an expert, but also in cases where he's been called by the other side, and I've had to cross-examine him. And that's really the genesis of how this talk came about, because we had a case that finished a couple of years ago, and we went out, as you do, for a glass of wine afterwards to discuss it. And we thought that the way that expert evidence is dealt with, particularly in this field, is often not dealt with in the best possible way. The deployment of the evidence is frequently undermined by the manner of the instruction of the experts. And we thought that it was worth having a discussion as to the steps that can be taken to perhaps resolve some of those issues. So what we're going to do today, hopefully, is to seek to provide some guidance as to how to gain maximum benefit from the expert in insolvency proceedings, and how, conversely, we hope to avoid mistakes which can diminish that expert's effectiveness. Now, during the course of the talk, if you'd like to ask questions, there's Q&A functionality at the bottom of your screen, and we'd ask you use that rather than raising your virtual hands, because I think there are quite a lot of you, and if you all raise your virtual hands, there's simply no way we're going to get to any of you. We'll go through your questions as we go through the talk, but we'll also answer questions at the end. So without further ado, let's look at the outline of what we're talking about today. What we're going to do is we're going to begin with some basic principles, which probably are familiar to all of you, both as to the admissibility of expert evidence and the role of the expert in insolvency litigation. We're going to deal, then I'm going to deal with evidence given by office holders, which is often an issue which creates difficulty since it sits in that uneasy position between expert and factual evidence. We're going to deal with instructions to experts, then preparing the expert's report, and finally deal with the use of expert evidence in bringing and defending claims against former office holders. So if we start then with the basic principles of admissibility, surprisingly perhaps, the civil procedure rules don't themselves provide any definition of what expert evidence actually is. An expert, the CPR says, is someone appointed by the court to give expert evidence, which perhaps is not a very helpful definition. I think we start really with what they're allowed to do and what they're not allowed to do. Opinion evidence is, by its nature, generally speaking, in evidence inadmissible, but an exception is made for the court to accept opinions and conclusions of experts on matters which require specialised knowledge or training, which the court does not possess. That much is straightforward. As to whether to permit expert evidence to be admitted, we know the general practice of the court is to say it's, generally speaking, better out than in, and to be very restrictive in terms of its admission. Generally speaking, the three-stage test in British Airways and Paul Spencer is referred to. And I can summarise what Mr. Justice Warren said in that case really in three simple bullet points. First, is it necessary? If so, you can have it. Secondly, if you can't show it's necessary, is it of assistance? Very obviously, if it's not of assistance, you can't have it. And thirdly, if it is of assistance, is its value such as to justify the expense and time associated with its use? And we'll be looking at evidence today which falls both in the former and the latter category. Now, Chris is going to talk a little bit now about the basic principles as to the role of the expert and how they guide the contents of the expert evidence.
Dan, thank you very much. And good morning, everybody. Dan has used quite a lot of words because he's a lawyer and he's got a lot of words on some slides you're going to be seeing. So I thought what I would do is just show you some pictures instead. Now, what I mean by this first picture is that sorry, I'm getting dreadful echo at the moment. Very difficult. That's better. That's better.
Chris, I think I'm responsible for that. I apologise for that. I'll mute my mic when you're talking. Sorry.
Okay. Apologies, everybody. What I'm intending to show by this diagram is on the left, the bottom left-hand corner, is a representation of the facts that are involved in litigation. The scales at the top represent the law, and the bubbles down to the right are the opinions. And those opinions are coming from the expert, who is carefully positioned far away in the bottom right-hand corner. And what I'm seeking to illustrate is that that's where the expert sits. He deals with opinions. It is not for the expert to decide what the facts are. It is not for the expert to decide what the law is. He, of course, uses the framework of the law and operates within that framework when giving his opinions. And of course, he gives his opinions in relation to what the facts may be. But I emphasize the may be because it's for the court to decide what the facts are. So that's my key point, that the expert deals with opinions within the framework of the law and in relation to what he assumes the facts will be. If we move on to the next slide, you'll be very familiar with the facts on the left and the expert at the bottom. What else am I representing here? Well, on the right, we have the court. And in the middle, we have the scientific instrument designed to help the court to determine the facts. And that really is the expert's role. That's why expert evidence is being adduced. It's because the court needs that specialist knowledge, that consideration, those opinions in that specialist area in order to be able to decide the facts of the case. I mentioned scientific, and one way you can look at this concept is the scientific method of hypothesis followed by testing followed by conclusion. And the expert is helping to test the hypothesis of the assumptions so that the court can come to an appropriate conclusion. And moving on from those basic principles, I mentioned assumptions. And I think it's really important that everybody involved appreciates that the expert cannot know the facts. He can only make assumptions and express opinion based on those assumptions. It's the court that decides what the facts are, but as an expert, you need to make assumptions about what the facts may be. And when you're making assumptions, just remember that you don't just make an assumption on what the evidence appears to suggest. What if, in fact, the court were to find something different? So remember to consider other assumptions than perhaps the obvious ones. And my final point about an expert's approach is that an opinion is pretty worthless if it's not supported by reason. Give your reasons for your opinions. Why? Because the judge can only test the validity of your opinion by considering the reasons for it. If your opinion is rational, if it's based on evidence that the judge is prepared to consider, then your opinion will have weight. It may not necessarily be preferred over that of another expert, but it's important to give your reasons to make sure that your opinions carry the weight they deserve. So Dan, back to you.
what I will do is I will unmute my mic before I start speaking.
Excellent.
Thanks, Chris. Just before dealing with expert evidence proper, I think I'm going to deal very briefly with an area I mentioned earlier that causes considerable difficulty, which is evidence given by office holders in support of their own cases, and the extent to which their opinion evidence is helpful or even admissible. Now, the rules are obvious and clear, and the lay witness must give evidence of fact, not opinion. The province of the expert is opinion and not generally fact. And this puts the IP giving evidence in support of his own case somewhere in between the two. For those of you who know it, he's a bit like Daddy Pig in Peppa Pig. He might say to himself, I'm a bit of an expert. Well, that's not, I suggest, the way that evidence should be presented. Generally speaking, it's advisable for the office holder to avoid purporting to give expert evidence in this way. And there are numerous examples of insolvency practitioners coming unstuck where they've attempted to give evidence in support of their own case. And it's possible to see through all of those a common thread, which is it's the fact that it's your own case, that you are the litigant in the proceedings, or that your firm is the litigant in the proceedings, that means that you cannot give opinion evidence of value which the court should have regard to. The first of the two cases I'm going to refer to is quite well-known case of Colt Telecom Group PLC. And in that case, an accountant IP was severely criticised by the court when he gave evidence for a company that was petitioning for another company's administration because he failed to disclose in the report that was presented to the court that his firm had recently acted for the respondent company, and also that his firm stood to gain if the administration order was made because the petitioner proposed to appoint his firm as administrator. While that's not a case where the IP's evidence was in support of his own claim, strictly speaking, the principles which Mr. Justice Jacobs in that case referred to are equally applicable, I would say, in those cases. And that is that if the expert had read and properly applied the code of guidance, and he refers in particular there to the guidance that where there is a range of opinion, it should be expressed, where there are opinions, the reasons for those opinions are given, but perhaps most importantly, where the evidence comes from a position not of independence, that the source of that evidence should be made clear. The expert could not have prepared the report which he did. I regret to say that I conclude without hesitation, however, that the expert failed in his duties to the court. Unconsciously, I think he espoused his client's cause. Moreover, I think he was prepared to act for Highbury when there was a clear conflict between his firm and that of a client, namely Colt. Of course, I do not say these things lightly. Now, the important point to come from that as well is that in that case, there's no suggestion that the expert was acting in a way that was intentionally designed to mislead the court or to support his own cause. It was the fact that he was deemed unable to do so by reason of his conflict and lack of independence. And the second case to refer to is Continental Assurance from 2001, which was a well-known wrongful trading and misfeasance claim brought by the liquidator of the company. It's much more analogous to the cases that we see where insolvency practitioners as liquidators, for example, bringing a claim, give evidence in their own cause. The evidence as to loss was provided by witness statements from a member of the liquidator's team, a Mr. Gill. That Mr. Gill had been very involved in the presentation of the case throughout, and the judge had seen him in court on every day, discussing the case with the liquidator's team. His evidence was both as to the facts giving rise to the loss claim. In fact, it was originally intended, I think, that his evidence was going to set out the facts and that an expert was going to comment on them, but that didn't happen. Ultimately, he gave evidence also as to his opinion as to what that factual evidence showed, and the court held that his involvement as a committed member of the professional team, the purpose of which was that these claims against the directors should succeed, does in my opinion mean that he was not a suitable person to be an expert witness. I intend no criticism of Mr. Gill in this connection, again something we saw in the earlier case. I'm sure that he believes that he was being fair and neutral when he was compiling his witness statement about quantum. I would not contemplate for a moment that he would think about slanting his evidence so as to favour the liquidators and disadvantage the directors, let alone consciously do it. But the fact is that Mr. Gill would have been superhuman if he could have approached the task of making the quantum calculations without being influenced by what he was convinced the outcome of them must have been. And that really highlights the difficulty that insolvency practitioners quite often face in giving evidence in support of their own case. That's partly a product, I think, of the way that evidence is often produced in its kind of hybrid form to perform the function both of a statement of case and also as the principal means of conveying the factual case. But how do you draw the line if you're an IP between permissible factual evidence and what would be considered inadmissible opinion evidence from an IP in support of his own cause? And actually, in the majority of cases, I don't think that question is difficult to answer. You know it when you see it. It's entirely appropriate for an IP, for example, to refer to Sage accounting records, the raw Sage accounting records, and to say that his investigations into these records have identified certain transactions which are unexplained and which appear not to have been in the interests of the company. As a matter of general principle, no expert evidence is required at all in that case, as that simply is a question purely of factual evidence. Similarly, where the evidence is actuarial in nature, for example, the calculation of loss by reference to accounting records, that's not actually an area where expert evidence is, generally speaking, required. It may be an area where expert evidence is desirable instead. Where problems arise is where a witness statement is filed by the IP and vouches an opinion. An example might be, for example, on an unlawful dividends case, where the IP analyses the accounts and the accounting information relied upon to declare the dividends and says that they're unreliable because they didn't comply with certain accounting standards. That would seem to me to clearly fall on the other side of the line and be the province of expert evidence, generally speaking, except perhaps in the clearest case. Somewhere between the two cases that I've said, there's the category of case where the use of expert evidence might not be necessary, since all of the evidence as to loss, for instance, can be put before the court in the form of accounting records. To use the example used earlier, where you have money that's left a company that's unaccounted for, you could put before the court all of the Sage printouts of all of the transactions. And the court could do its best, looking at all of those records with the assistance of the legal teams, to work out what the right figure would be. But that's a situation where accountancy evidence falls into the desirable category and may be used as a quicker, less expensive, and I hesitate to say it, but probably more accurate way than the court simply forming its own view based upon the accounting records that are put before it. And that really leads to another area which perhaps gives rise to particular difficulties in the expert evidence field when it comes to insolvency litigation, which is tax and taxation law. Judges are perhaps understandably resistant to admitting expert evidence on what the law of England actually is. They feel, perhaps not unreasonably, that's a question they are qualified and indeed appointed to answer without the benefit of expert evidence. So in those circumstances, I would say that the use of expert evidence is not appropriate. And to give you one example as to how this might come up, you may have a case which is brought by a liquidator for misfeasance against directors who've entered into an employee benefit trust. And there may be a question in terms of calculating the loss to the company in terms of the tax liability that arises either on the case that the payments are unlawful distributions, or on the counterfactual case that the payments are lawful remuneration, and come to a figure to establish what that tax loss actually is. Now, that would seem to me to be a point that's squarely within the realm of English law, but one which I think, for my part, I'd feel a little uncomfortable answering without the benefit of specialist assistance, and I think quite a few judges would as well. I think the answer to that in those cases is to have specialist tax counsel sitting alongside insolvency counsel to deal with those discrete issues, and to exchange skeleton arguments and statements of case that deal with those particular issues. And if the case is sufficiently complex, to have tax counsel attend trial. And the other way it can be dealt with is to, in the more complicated cases, ask for the trial to be listed before a judge with tax experience. That's about all I intended to say about different categories of expert evidence that you might encounter in insolvency litigation. I think we come on to really the main thrust of this talk, which is the instructions to experts and how best to deal with that, because that is often where things go wrong, as we'll see. Generally speaking, as we know, instructions to experts are not disclosable, though the content of the instruction should be included in the expert report itself. It's a bit like making sausages. For some reason, people don't seem to want to disclose how these things are made to the other side, at least in the form of letter of instruction, although the instructions are included in the expert report itself. And as we will see, of particular importance, the instructions as to the factual evidence. There are a number of points to make in terms of the contents of those instructions. An expert witness, as Chris has already said, is to assume facts for the purposes of giving opinion evidence. So he's to base his conclusions, his opinions, on certain factual findings ultimately being made by the judge. Chris has already mentioned the role of the expert being to provide his opinion on this basis rather than to act either as a tribunal of fact, or the second point, to pursue a line, a slanted line. For example, if you have a letter of instruction from your own party which presents a skewed view of the facts, which you hope the court will ultimately find. Of course, that's perhaps okay if that's the finding the court makes, but leaves you very much exposed in the event that it doesn't. So it really comes down to showing the assumptions which you're making and showing your workings in terms of how they affect the ultimate result in terms of your opinions, as Chris has already said as well. Really, the better approach in terms of instructions is to provide the factual background, but highlight areas of difference between the parties. And the expert can then provide an opinion based either on some or all of the findings of fact that the court may make. And a graphic example of all of this going catastrophically wrong is the recent case of DeSena and Notaro, which was heard by His Honour Judge Matthews. It's an unusual case involving a corporate demerger. And the claim was brought against, first of all, the first two defendants for the demerger having been procured by undue influence. But there are also claims against a firm of accountants and a firm of solicitors. Now, being a firm of solicitors, obviously there was no expert evidence in terms of the duties that they owed or the breach of their duties, but there was expert evidence adduced and called by both parties as to the role of the accountants in the demerger. The allegation being the accountants had acted in breach of their fiduciary duties and in breach of the duty of care said to have been owed to the claimant. So things went very badly wrong almost immediately, in that the experts called had to accept and had to tell the judge that they weren't actually particularly experienced in the field of demergers, coming from a general accountancy background. And that was enough for the judge, it appears, to conclude that their evidence was not appropriate expert evidence and was unlikely to help him. But he did go on to look at the instructions that were provided to the experts. And what he saw when he looked at those instructions was a long list of questions being put to the experts that ranged far and wide in terms of factual questions for them to answer as to what it was that the accountants did and what it was that their retainer required them to do, questions of law equally as to retainer and duty of care, and very little actually as to the relevant question, which is whether they had fallen below the requisite standard of a reasonably competent firm of accountants with knowledge and experience in this particular area. So the judge said, I have to say that I've never before seen such an extraordinary set of questions put to a witness being asked to give expert evidence. I'm unable to regard the answers to any of these questions as admissible evidence in this case. I'm astonished that these questions were asked at all and almost astonished that they were answered. And he went on, overall, therefore, in relation to the evidence on accountants' liability, I have disregarded both sides' reports. I deprecate the undoubtedly significant expense which has been wasted on this aspect of the case, but it behoves the parties and their lawyers, when permission is given for such evidence to be obtained and adduced, in implementing that permission, to pay close attention to the rules regarding the admissibility of expert evidence. Permission to adduce expert evidence on a topic by calling an accountant or anyone else is not a license to ignore the rules as to what expert evidence is and who can give it, or the conditions under which it is admissible in legal proceedings. So purely by reason of, well, if one sets aside the fact that these particular experts weren't actually qualified to provide an opinion in the area, they were actually vouching an opinion. But even ignoring that slight problem, just looking at the way the instructions were put to the expert created such difficulty in terms of the reports they put forward, in terms of separating what was admissible, valid opinion evidence and what was simply usurping the function of the court and making findings of fact and the like, meant that it was of absolutely no value to the court. And Chris is going to say a little bit more about instructions to experts now, but this time looking at it not from the point of view of the lawyer representing one of the parties, but from the point of view of the expert, particularly an expert with a duty to the court.
Thank you, Dan. I really want to underline what Dan has just said, and I absolutely recommend anyone involved in expert work, whether you're a lawyer or an expert, to read the questions in the De Sena and Notario case, just to appreciate what shouldn't be in a set of instructions. And I'm going to give you another example. Again, a recent case, Akebia Therapeutics and Fibrogen, which was a patents case decided last month. And in that case, Lord Justice Arnold said, it is vital that the task of the experts is not made more difficult by the lawyers than it needs to be. And he went on to say, the lawyers who instruct expert witnesses bear a heavy responsibility for ensuring that an expert witness is not put in a position where he can be made to appear to have failed in his duty to the court, even though he conscientiously believes that he has complied with that duty. And finally, both experts were let down by those instructing them with respect to the preparation of their expert reports. It should not be necessary for me to say that this is unacceptable. These are matters of professional responsibility. If practitioners continue not to observe the standards required of them, the Patents Court will have to take steps to enforce those standards. So, more pretty strong judicial words about instructions to experts. From the expert's perspective, what I would say to those instructing experts is, I suggest you don't be too prescriptive too soon. An expert is an expert in the field in relation to which he's giving opinion evidence. And the court either needs that evidence or it would be of value for the court to be assisted. I suggest that the legal team probably also needs a degree of that specialist assistant or would be valuably assisted by it. And it's quite important, therefore, that the direction of travel of the whole exercise isn't set too firmly in stone before the expert is able to bring his expertise to bear. And one of the consequences of that approach is that early involvement of the expert can very often help to focus the claims that are being made in the litigation. Another point about instructions is that any gaps in the factual evidence will lead to the expert making more assumptions and exploring more counterfactuals, lengthening and complicating the exercise. Now, you might think that those 2 points I've just made about bringing the expert in early and not having gaps in the factual evidence are conflicting. I don't see it that way. I see part of the expert's role being to help identify what are the key issues to be addressed so that valuable assistance can be given to the court in that area of specialist knowledge. Moving now to my field of advising on insolvency practice, one of the observations I would make is that starting from the so far pleaded case can detract from the expert identifying what the reasonably competent office holder would do in the circumstances. And that's a specific example of the more general point I was just making. Having a case that is too firmly nailed down can make it quite difficult for the expert to unpick some of the way the material is put together to say, here are the key points at which I need to assist the court by giving an opinion as to what a reasonably competent office holder would do in this assumed set of circumstances. Because in that type of case, that's fundamentally the expert's role. Dan, back to you to talk a little bit more about professional negligence and breach of duty type cases. When you unmute your microphone.
I will get used to that eventually. We're getting lots of questions come in. I think one of the questions, Chris, that I'm being asked to ask you is, do you have the citation for the case you were just referring to at the start of your of that passage?
Yes, I do. If I can get it up quickly, flicking between machines. But I will give that when I next speak.
If we move on, what we're going to talk about next is really the, as I say, the most important part of all of this, which is, and I think also for Chris, the area in which his expertise is most frequently called upon, which is bringing or defending claims that are brought against former office holders. There is, of course, the general requirement in all professional negligence cases that the expert evidence, so that the claim be supported by a fellow competent professional as to whether or not the conduct in issue fell below the standard of care to be expected from an ordinary competent practitioner carrying out the task in question. And that's generally speaking a requirement for any professional negligence case, subject to the exceptions we'll consider in a moment. It's a feature typically of cases where claims are brought against former office holders that the court's leave is required to seek relief against the former office holder after his or her release. And that raises the question as to, when showing that the claimant has a case of sufficient strength, whether or not the support of an expert is required at that stage. And that was considered quite recently in the One Blackfriars case, which I know is a case that Chris is involved in as one of the experts. The question was answered in the negative by the court in that case. The deputy judge held that the claim is by liquidators who are insolvency practitioners and officers of the court against former administrators who are also insolvency practitioners. The allegations of breach all relate to acts or omissions by the administrators while carrying out functions in their capacity as such. They do not, on the face of it, require an understanding of what it is that a reasonably competent insolvency practitioner can be expected to do, which is any greater than that which the liquidators can be expected to have. And that finding didn't mean that expert evidence wouldn't be required by the time the claim came to trial, simply that there was a sufficient case made out without the benefit of expert evidence at the commission stage. Now, as I say, that general principle is subject to some qualifications, and perhaps particularly in the area of insolvency litigation, because the majority of these claims that are pursued in front of specialist judges who, much like the liquidator in the One Blackfriars case, is a specialist and may say that he's able to form his own view on many cases as to whether or not the standard of conduct by the former office holder fell short. And that's really the first exception. And it's those cases which are obvious, or those cases which fall within the specialist knowledge of the tribunal, but not involving particularly recondite or difficult areas of assessment. Typically, as occurs in solicitors' negligence cases, a judge doesn't need another lawyer to tell him whether or not someone has fallen below the standards to be expected of a reasonably competent lawyer. As to ordinary matters arising in the conduct of litigation, insolvency litigation, an experienced company court judge may well be able to form a similar view, where the question is whether or not an IP has followed a provision in the Insolvency Act or a particular rule. A similar finding was made by the judge. In fact, it happens, the same judge as in the Desena case, in the case of Devon commercial property, where I actually acted for the LPA receivers. In that case, the LPA receivers were alleged to have sold a cider factory to their appointer at an undervalue, thereby acting in a situation where there was a conflict of interest and they were said to be preferring the interests of their appointer. Both parties adduced expert evidence from IPs as to the standards required of LPA receivers and whether or not they had been met in that case. And the judge held that although the court could not normally decide that the conduct of a medical practitioner fell below the standard of care required of a reasonably competent practitioner without expert medical evidence, the court regularly decides that the conduct of motor car drivers falls or does not fall below the standard required of a reasonably competent driver without any expert driving evidence at all. Whilst I am far from equating the actions of LPA receivers with those of motor vehicle drivers, I am clear that, in the ordinary run of cases at least, the court really does not need expert evidence to be able to tell when somebody manages or sells land or interests in land badly. As Dr. Samuel Johnson is reported once to have said, "You may scold a carpenter who has made you a bad table, though you cannot make a table." Now, the judge compared the situation to cases where the court does not receive expert opinion evidence from professional trustees or company directors in order to decide whether the defendant trustees or the defendant company directors had acted in breach of their duties. But I think it's important not to take the point made here by the judge too far. The LPA receivers in this case were alleged, ultimately unsuccessfully, but they were alleged to have sold the asset in question in circumstances where they had a conflict of interest. And as a result of that conflict, sold the asset in undervalue. That's an allegation which is not in reality an allegation of professional negligence. It's an allegation that the LPA receivers acted outside their permitted powers and as a result should be strictly liable for the consequences. This was therefore not really a case about assessing the professional decision-making of an IP, but simply deciding whether they had or had not acted within their powers. Looking at codes of practice, and this is an area I think where Chris is often called upon to give expert evidence, codes of practice within the profession, such as statements of insolvency practice, will always be given considerable weight by the court. Though not conclusive, they may well in effect raise a presumption of negligence if they are materially departed from, which can only be rebutted by the clearest evidence. There are obviously good reasons for taking the view that a standard generally and formally endorsed within a profession and thus codified is the appropriate one. The question arises, well, to what extent is expert evidence needed on this point, given that you're looking at codified standards and those standards could just be placed before the court? In the very clearest case, the court may be in a position to form its own view looking at the standard practitioner guidance. And that was the case in the Industrial Services Group Number 2 Limited. This was an application to remove a liquidator on the basis that his firm had advised the director and shareholder of the company before his appointment, so that he should not now act as liquidator. And the applicant sought permission, the applicant seeking removal sought permission to rely upon an expert report concerning SIP 13 and the disposal of assets to connected parties in an insolvency process. And the court took the view that whether in fact Mr. Jones observed the various statements of guidance in SIP 13 is again a matter on which it seems to me that no expert evidence could be adduced, although it might be a matter for expert opinion whether the procedure that was adopted by Mr. Jones was generally in accordance with the good practice of insolvency practitioners or not. So the reason why the expert evidence was excluded in that case, or permission for it wasn't granted, was that the court concluded that it did not seem that evidence as to what generally good practice as to what was generally good practice was material to the issues likely to arise. Or to put it another way, the court said that whether or not there had been a breach of SIP 13 was really a binary question, either there had or there hadn't, and that was all that mattered on the facts of that particular case. And for that reason, there was no need for the expert evidence. However, if the question, and in most cases it will be, if the question is one of fact and degree, whether the exercise of judgment by the insolvency practitioner was in accordance with generally accepted good practice, as outlined in the Statement of Insolvency Practice, expert evidence is likely to be necessary. The question then is one of judgment, when the view of an expert as to what the generally accepted practice in the profession is relevant, and not simply one of binary compliance with the SIPs, for example. And Chris is going to say a few more words about that.
Yes, thanks again, Dan. Certainly, as far as the SIPs and the Code of Ethics is concerned, to my mind, in breach of duty cases involving former office holders, it may well be relevant for the expert to look into quite a number of aspects of the Code of Ethics and the SIPs in order to be able to set the context of what a reasonably skilled office holder would do in the circumstances that are being assumed. And I see going to those to that professional guidance as being part of the rationale for the opinion that the expert is giving. This is what a reasonably competent insolvency practitioner would do in these circumstances because such and such is required by the professional guidance. Coming back to these types of cases and what the expert really needs to be able to express useful opinions on what has gone on. In my view, as the expert, you really need pretty much the office holder's complete files, even though that's probably unlikely. It's probably unlikely you'll get it even after disclosure. And the office holders and the office holders' staff's file notes, which of course are regulatorily mandatory for key decisions, are particularly valuable. Why is that? It's because it is contemporaneous evidence on which the court is likely to put a good deal of weight. And the better idea you have of as the expert of the likely acceptance by the court of any particular set of assumptions you make, helps to ensure that the opinion evidence you're giving is firmly grounded. In the same way, I think one of the things an expert is going to want to do is to think through and document all the relevant parts of the office holder's assignment from the perspective of a reasonably competent office holder. And that may involve establishing counterfactuals, because if the reasonably competent office holder would not end up where the practitioner ended up, you need to look at all the decision points along the way. And the best way to do that is to create a timeline, to look through the whole thing. And at each time there's a decision, what would the reasonably competent office holder do at that point and why? And if you can take the court in a report through that thought process, it will help the court to appreciate and determine whether what in fact the court decided the office holder in that question did fell within what a reasonably competent office holder would have done. And I'll just re-emphasize here that it's not for you as the expert to say, I think that what the office holder did was not good enough. And it's not similarly appropriate for the expert's instructions to ask the expert that question. But of course, as an expert, you may need to identify evidence of what the office holder did or didn't do in order to explain the factual assumptions on which your opinions are based. And you may then report that you've seen no evidence of the office holder doing X, where X is what, in your opinion, the reasonable office holder would do given the assumed facts. And as Dan knows, my approach in this circumstance is very much not to say what I think the office holder did or didn't do. My approach, and it's one I recommend, is to focus on assumptions about what the facts were and work from those assumptions to express opinions about what a competent office holder would do in those circumstances you've assumed. My reference then to Dan is a good lead-in to Dan starting to talk about another example we want to share with you, which is the case of Brewer and Iqbal. And in that case, Dan asked me that very question. Was I seeking to usurp the function of the court by determining what his client had or hadn't done? And I was able to satisfy the judge quite straightforwardly that I was not seeking to usurp the court's function. But Dan, was that your perspective?
That was one of my better points, actually. I mean, just to give you a little of the background to the case, it's I think it was last year or the year before, I can't remember which now, but it was heard by Chief ICC Judge Briggs, and it was brought by a liquidator against a former administrator of the company, where the former administrator had come in on the eve of administration, and there were a number of television channels effectively within this company, which the directors of the company assured him had very minimal value. And what he did was he sold them to a new co, operated by the same management as in the usual way, the same management as the company in administration, as it turned out at a rather substantial undervalue. And there were two cases run against the administrator. One was that he was dishonest, and that didn't get anywhere. That lost, and I should say that wasn't the subject of Chris's expert evidence either. That was a point of pleading and submission. But the other case was that he'd either surrendered his judgment making to such an extent to the directors that he wasn't acting in accordance with his fiduciary duties, or that he was negligent. And Chris was called upon to give expert evidence in support of that claim, and I was called upon to cross-examine him. And from the facts you'll gather, cross-examining an expert in those circumstances is not a great deal of fun, because there's not an awful lot that you can do, because the SIPs are the SIPs. And if they should have applied, and if they suggests that the defendant has fallen below a reasonable standard, there's not a huge amount that you can do about it. But what you can always get from an expert in those circumstances is a concession, because every expert who's doing his duty will have to give it to you, that certain findings they make in terms of breaches of the SIPs or whatever else they may have failed to do depends upon the factual findings of the judge. And if you can persuade the judge, as a matter of fact, that those factual findings are flawed, that's really your way to get in and attack the expert evidence. I don't think the way to get in and attack the expert evidence, unless you've got clear evidence that he's not an appropriate expert, or he is in some way inappropriate to give expert evidence, none of which obviously I put to Chris. Unless you can do that, then that's really, it seems to me, the way to get in and attack the evidence of an expert. Either that, well, that in terms of standards evidence. There may be other attacks that you can launch in terms of logical findings or illogicality in the opinion that's given based upon the reasoning that's shown, that sort of thing. But certainly when you're dealing with pure standards evidence, that really is the only way I think that you can attack it, is to really attack the underlying facts. Is that a fair way, Chris, of putting my cross-examination of you?
Yes, I think it is. I think it is.
Very polite anyway.
Yes, it was inordinately polite. I think that's probably what led us to go off and have a drink sometime later.
Yeah.
But
yeah.
No, I think you're right. In a sense, I feel slightly fortunate as an expert in that I do practice in an area which has that facility to be able to refer frequently to professional guidance. That whilst it's important to recognise that mere breach of professional guidance doesn't constitute some wrong that the judge will seek to right, what it does do is set in context what you are doing as the expert, which is saying this is what a competent professional would do in this particular set of assumed circumstances, and that is what he'd do in another set of assumed circumstances, and use that information to give the judge the equipment to be able to look at what he decides the facts of the case are and make his own assessment in relation to breach of duty, negligence, etc.
Yeah, I'd forgotten, Chris, that when I cross-examined you, you gave very comprehensive answers as well. So another demonstration of that. Thank you. Can I ask you another question?
Go on,
which is a question from Tim Symes, which is that maybe a question for both of us. Should it always be an expert accountant that prepares the net deficiency statements to determine quantum in a wrongful trading claim, or can the IPs prepare the same? I mean, my view in terms of that is it's really a question of the complexity of the case. I think if it is, I mean, like I touched upon earlier on, if it really is a question of looking at the sage records, and that, you know, a simple lawyer, if you like, can make the points good without, by reference to the facts that are attested to in the office holder's statement, then that's probably good enough. But generally speaking, those are cases where there are quite a lot of different contingencies and things built in, which make the position quite difficult for a lawyer certainly to do that. So that it's really is an area where, generally speaking, I think expert evidence is generally speaking required, but not essential. I was also going to ask Chris a question which I think really goes to the heart of what we've been talking about today, which is a question from Noel McMichael, which is, do you think it's permissible for the expert and the lawyers to work together to formulate the questions for the expert report? Or is that a matter which will compromise the independence of the expert? Do you have a view on that?
Yes, I think that's a very helpful question to have asked.
Yeah.
When I was talking about the preparation of instructions, what I had in mind was the underlying issues within the expert's area of expertise. So if we take an insolvency practice case, I certainly wouldn't be expecting to work with those instructing me on what those instructions were going to be. That's for them to determine what the instructions are. But what I think it's helpful for me to have done before they finalize those instructions is to look at the case and make the point that from an expert point of view, an expert in that field, these are the critical issues to concentrate on. Yeah. And certainly my experience is that even lawyers who tend to litigate in the area of insolvency don't have quite the same approach to what may have gone on in the circumstances as an insolvency practitioner. As an insolvency practitioner, you've been there, you've done that, you've been in that position, and you know what it's like to be making those decisions at that time. And few lawyers have had that privilege. And that's why I think it's important to get the balance right. It's the underlying issues that it's important for the expert to have been discussing with the lawyers, so that the lawyers can properly formulate instructions that are constructive and comply with all the other points that Dan made earlier.
Yeah, and of course, I mean, there's nothing insidious or troubling about that, is there? Because ultimately, what you're being asked to do and what you're being asked to answer will always be disclosed in your report. So you're not doing anything that you shouldn't be doing. You're not shaping inappropriate questions. On the contrary, you're shaping appropriate questions. And I think probably if you're in the position of an expert and you were faced with instructions like those the experts in the Desena case had, you would expect to go back to your instructing party and say, I don't think this is the right way to do this. And I can't see any difficulty with that. We've got another conflict question, which is from Charlotte May, which is, how do you approach the risk of conflict where the expert is in the same firm as the IP? Does it depend on how big the firm is? Can we ever be confident that an expert keeps a track record of all business they have worked on to ensure conflict is avoided? I had some views about this because I was in a case last year before Deputy ICC Judge Schaffer involving an allegation of conflict on the parts of the IP, which I know you've spoken about before, Chris, at R3 events and the like as well, called DCL Hire. And I think there are really, from my part, there are really two questions here. Where you have an IP conflict issue that arises, it's one thing for example, an IP to bring litigation when he's also appointed in respect of other companies, when there's, for example, a big fraud involving lots of companies. It's one thing for the IP to do that, but it's another thing for the IP to act as expert. And I think it's much more difficult to see circumstances where any kind of steps taken to maintain separation for the expert would be sufficient to provide the necessary assurance of independence and everything else that goes with being an expert to meet the requirements of Part 35. Do you think that's an unduly harsh view, Chris, or are you?
No, I thought you put it very mildly, Dan.
Oh, I know I always do. You're always much tougher on people than I am.
I'd just say you can't be an expert in relation to a matter brought by somebody in the same firm. I think your interests, I think that's an irreconcilable conflict. As an expert, your duty is to the court. Your primary duty is to the court. It's an absolutely fundamental thing about being an expert. And if someone else in your firm is one of the parties, you just can't, it just doesn't work. The conflict is too great. And so I don't think it depends how big the firm is. And I think that there just has to be separation there.
Yeah. I think that brings us up to midday, Chris. So I think that's probably...
Yeah, just a couple of points to make. I have put on the chat function the case I quoted earlier, Akebia Therapeutics Inc. v. Fibrogen Inc. 2020 EWHC 866, PAT. Somebody's also asked for the Brewer and Iqbal reference. It's Brewer and Iqbal 2019 EWHC 182CH. I'm not going to write that down because I've just told you all what the answer is. I think that probably covers all the questions. Just trying to flick through them. Someone suggesting, Andrew Scott suggesting that in Brewer and Iqbal it might have been a binary matter. Was there a breach of the relevant standard? And was it actually necessary for me to give expert evidence in that case? Well, I think it's fair to say that in Brewer and Iqbal, and you'll have a view as well, Dan, that it wasn't simply breach of a professional guidance, breach of a SIP that was at issue. It was the conduct as a whole, which went well beyond breaches of professional guidance. The questions were about breach of duty of care and breach of fiduciary duty.
Yeah, and I think the other thing about that case was that the reason why I think, I certainly felt sympathetic to the defendant's position was that he was faced with quite an unusual situation. It was an unusual asset that he was being asked to deal with. Now, not necessarily an answer to the claim as it turned out, but he was acting, we say, under extraordinary time pressure. There were questions about the extent to which he was entitled to rely upon the instructions, or not the instructions, that's the wrong word, the information he was being given by the directors of the company. All of those meant it was much more complicated at the end of the day than a binary question. Although when you read the judgment, you might think that the judge didn't find it too difficult to find him liable for the lesser claim, not the greater claim.
Well, Dan, I think that does bring us to past time. I would thank the 150 or so participants we've had, which is a very impressive number. It was no doubt your name in the headlines, Dan, that brought everybody along. All I would say is thank you for attending, and do look out for more web-based contributions from Wilberforce Chambers and Mercer Hole, whether they're webs, chats, webinars, or whatever. Both organisations do provide plenty of professional entertainment during these times when we have to spend more time on the systems than we might normally want to. But thank you very much, everybody, and goodbye.
Thank you. Bye-bye.